Good evening. Happy Thursday, around 1 million. We're going to go over the Ironton filings from today. If you remember, the judge entered a judgment in Ironton on the 6th, on December 6th. So these are documents 29, 29.1, and 30. So 29 is Chili's motion for leave to file a response to defendant's judgment on the pleadings and to otherwise respond to order to show cause after the deadline. So comes now Jose Maria Decastro files his motion for leave to file his response after the deadline has passed. He makes a request for a 2-day enlargement of time. He needs to actually ask for a 4-day enlargement of time, and I'll tell you why. It was due on the 30th. If he files by mail, basically if he files by really any way other than ECF, then he gets 3 additional days. 1, 2, 3. Now, because it falls on a Saturday and the clerk isn't open on Saturday, it then continues until the next day the clerk's open, which is on the 5th. That's 3 days. Now, if you got 2 extra days, he would get 1, 2, 3. It would be the 5th again. So what he's actually looking is 4 days, which would be a total of 7 days, which would get him 1, 2, 3, 4, 5, 6, 7. That's what he's looking for. Now, the court is going to probably read this in such a way as to understand what Chili's actually asking for, even though he didn't ask for it right. Cause. The court should grant plaintiff's request for an extension of time to respond to defendant's motion for judgment on the pleading until 12/7/22 in consideration of the following. Number 1, the extension of time for 2 days will not prejudice any defendant, as this is the initial stage of the case. Well, actually, the case has been decided. It's now over. So it would prejudice the defendants, as they would have to all of a sudden start defending the case that they've already won again. So that would really prejudice defendants. That's a pretty big prejudice to place on defendants. 2, the delay in filing plaintiff's response in opposition to the motion to dismiss is due to excusable neglect and was not intentional. I don't know what he really finds excusable neglect to be, but we'll see. The potential impact of the delay on the judicial proceedings is not significant. There is no foreseeable change to the court schedule, only that should defendants choose to reply to plaintiff's opposition, 30 days would be added to the actual date. Again, there's a fairly large impact. This case is done. It's settled, or it's not settled, but it's decided. It's closed. I don't know why he thinks that I don't know. I just don't know. Plaintiff has acted in good faith, but has been hindered in that he has not received 2 of the 3 orders to show cause, which resulted in delayed responses from plaintiff to this court. He hasn't received 2 of them, which means he received 1 of them. So why didn't he respond to that one? What? Whoa, Raggy. And additionally, this right here, you have to use an address where you can actually get service. If you're going to be getting service by mail, you have to use an address that you can get service, because when the court sends out its order to show cause, it's going to send it to the address that you've given it. And this is the address that you've given it. So if you don't receive your mail there, that's your problem, not the court's. It's your obligation and responsibility to apprise the court of any changes to your address, your phone number, your email. It's your responsibility. If you don't receive it, that's tough titty, said the kitty when the milk went dry. 5, plaintiff sent his response to defendant's motion for judgment on pleadings to his process server for filing, and they, i.e. the process server, arrived at the court late for filing in person on Monday, December 5th, which is within the deadline for responding. No. See, it's late. He arrived late. The court had to receive it by the 5th. With ECF, you have until, I think, like midnight to file on the date it's due. So if you get it in there at 11:59 at night, my dog is snoring hell loud. But if you get it in there at 11:59 at night on the day it's due, then you're good. But if you're filing it by mail, or if you're filing it by mail, the court has to receive it that's why it gives you the extra 3 days. It was due on the 30th. They give 3 extra days in case there's a delay in the mail, but it has to arrive in the mail on that 3rd day. If you're having it delivered in person by a process server, for some reason you still get that extra 3 days. I don't understand why, but they have to get it to the clerk on that 3rd day. So no, it's late. The process server did not arrive in time. It arrived late, which missed the deadline for responding. After finding that the motion was not filed, plaintiff needed an additional day to prepare and send his motion for leave to file with the response. And there is no declaration from the process server. There is no excuse given by the process server. There's no reason given by the process server. You just have Chili saying his process server was late. Oopsie doodles. Well, G-Court, my process server was late. Oopsies. Conclusion. For the foregoing reasons, plaintiff respectfully requests he be granted a 2-day enlargement of time and that this court accept and file his response in opposition to defendant's motion for judgment on the pleadings. Now he's attached his response in opposition to defendant's motion for judgment on the pleadings. And he comes now, yada yada. Summary. Plaintiff is a videographer, vlogger, and civil rights activist who has been publishing on media forums such as YouTube, Facebook, Instagram, and the like since approximately 2020. On Tuesday, March 29th, 2022, at approximately 4 p.m., plaintiff and approximately 14 other individuals were in the Ironton City Hall waiting hours for a permit for use of one of the rooms for a constitutional teaching session. At approximately 5 p.m., a City of Ironton employee announced that the building was closing. At approximately 5:03 p.m., Wagner approached only plaintiff and began yelling at plaintiff to, quote, cease and desist his unlawful activity, end quote. However, plaintiff was arrested before he even knew what Wagner was referencing as unlawful activity. Plaintiff was not allowed to leave the building, but was arrested by defendants, yada yada. The other 14 individuals were not yelled at or arrested, but were given time to leave the building. You know, there's a video of this. Just so everybody knows, there's a video of this. Plaintiff was taken to the booking area where several criminal charges were brought against him. In addition, plaintiff was patted down, searched, all his property taken, including his wallet, car key, and his iPhone 12 Max Pro, and miscellaneous other items. While in custody, plaintiff's social security number was extracted from him under threat and duress. Yeah, dude, you have to identify, you dumb shit. After posting bond, plaintiff was released. His property was returned with the exception of his iPhone date return. I think he meant to put in the date his iPhone was returned, which would require numerous demands and finally filing a replevin to retrieve. Once the iPhone was returned, it was evident that it had been searched and damaged. Numerous other harassments have continued against plaintiff since this original incident, which seemed to be designed to prevent and deter his First Amendment protected activities to record the police and other public officials and to report on their activities in Ironton. Are you sure it's not to prevent you from having constitutional teaching sessions or some shit? Number 2, Memorandum of Points and Authorities. A, legal standard for judgment on the pleadings. Federal Rule of Civil Procedure 8A2 requires only a short and plain statement of the claim showing that the pleader is entitled to relief. You know, isn't it weird that when it's Abrams stuff, it's not sufficient to have a short and plain statement of claims, and then when Chile does it, it's plenty fine. 10. To state a claim under 842 U.S.C. 1983, a plaintiff must set forth facts that, when construed favorably, establish 1. The deprivation of a right secured by the Constitution or laws of the United States, 2. Caused by a person acting under the color of law. Well, there are a few other things that they're going to, he's going to have to end up proving, but okay. A motion to dismiss under 12b-6 of the Federal Rules of Civil Procedure challenges a complaint's compliance with the pleading requirements of the federal rules. In addition to a motion brought pursuant to Rule 12b-6, the reviewing courts, accepting all well-pleaded facts as true and viewing those facts in the light most favorable to the plaintiff. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. I wonder where he I wonder where he copied this from. Because these are proper citations. I wonder where he got it from. Let's see if we can't find it. Did he misspell complaints? He did. No, he didn't. Okay. I wonder where he got it from. Sorry. I know you guys hate it when I go off on those little tangents. He definitely he cut this from somewhere. I just don't know where he cut it from. Because he doesn't actually cite like this. And see this weird break here? This is probably caused by it being like copied from a PDF pasted into a Word document and not catch the weird breaks. I mean, those are beautiful citations. Sorry, I got lost there. Factual allegations that only permit the court to infer the mere possibility of misconduct do not constitute a short and plain statement of claim, showing that the pleader is entitled to relief as required by FRCP 8A2, explaining that Rule 8 does not require detailed factual allegations. I mean, these are gorgeous. This is definitely not his writing. Moreover, a complaint will not be dismissed merely because it contains an imperfect statement of legal theory supporting the claim asserted. I just want to know where he definitely stole this from somewhere. Analysis of a 12b-6 motion is confined to pleadings and attachments thereto. An evaluated motion to dismiss. Hold on a second. Do I have Ironton? Do I have the updated Ironton docket? Let's go look it up, shall we? Ohio. Sound good to you? Let's look it up. No dead air, guys. No dead air. We'll keep talking. I know you guys love it when I just go silent and get lost in thought looking for something. All right, we're going to go to a docket report. And we're on 29, so we're going to go 20. We're going to go 20. I'm not going to do that. We're not going to do that. We're just going to do that. All right. So there's a motion for judgment on the pleadings. So for the 12B6, the motion to dismiss for failure to state a claim, that was Chapman. He was ordered to respond in writing by 11/17. That was the 12B6. The one that he had to respond to by 11:30 was the judgment on the pleadings. That's the judgment on the pleadings. So all of this where he's talking about 12B6, he has... Okay, here's the motion for judgment on the pleadings. So this one was due on the 17th. On the 17th of November. It's due on the 17th of November. So add 3 days, 1, 2, 3, give it an extra day. So it was due on the 21st of November. So he filed it 14, 15, he filed it 16 days late. 16 days late. So here's for the motion on the pleadings. Defendants in their motion for judgment on the pleadings claimed that probable cause existed for the arrest on March 29, 2022, based on assertions that at 5 p.m. plaintiff was notified the building was closing and refused to leave when told to do so when he was not privileged to be there. Defendant's argument is summarized in their statement. Thus, by plaintiff's own admission, he remained on the property after closing and refused to leave when told to do so. Therefore, the Ironton defendants had the probable cause to place plaintiff under arrest. And this is one down here, docket 23, page ID 171. In fact, plaintiff did not refuse to leave when Wagner approached him, but was surprised and standing stationary. There is a fucking video he's citing to the first amended complaint. Wagner held her hand out in a stop position and plaintiff was effectively seized at that moment. So a cop merely by holding out her hand seizes you. Okay. He did not feel free to walk away from Wagner or leave the building. Even when Wagner was telling him to leave the building, he didn't feel free to leave the building. That's new and exciting. A seizure by means of a show of authority requires both a show of authority and submission to that authority. An officer effects a seizure by means of a show of authority when the officer's words and actions would have conveyed to a reasonable person that he's being ordered to restrict his movement, and those words and actions actually produce his stop. So the reasonable person standard is not you. It's not Chili Decastro. It's the average reasonable person. So you, as a average reasonable person, if a cop was walking up to you with their palm facing towards you saying, leave the building, would that be a stop? Would he be telling you to stop and stay there? Or would the average reasonable person think that the officer was telling you to leave the fucking building? I mean, this is a pretty shit argument, dude. Certain circumstances might indicate a seizure, even where the person did not attempt to leave, including the display of a weapon by the officer, which shouldn't happen, or the use of language or tone of voice indicating compliance with the officer's request might be compelled. Yeah, the language and the tone of voice indicated you need to leave the fucking building, you dumb shit. It is the totality of the circumstances that is evaluated. The totality. Not just the hand, dude. It's the totality. It's the officer telling you to leave the building that you have to combine with the hand gesture. In this case, plaintiff was also surrounded by other defendant officers. Here, plaintiff expressed he was willing to go with them, i.e. out of the building. I'm more than willing to go with you. Then Wagner interrupting him, saying, you will? Let's go. First amended complaint. Plaintiff realized they were not escorting him from the building, but arresting him. Plaintiff then stated, "If I'm under arrest, I'll go with you." Then he was formally arrested. None of the other approximate 14 people were arrested, but were simply allowed to leave. Plaintiff immediately yielded to the officer's show of authority and did not refuse to leave the premises, as demonstrated in the pleadings. It is well established that every person has privilege to enter public buildings. Plaintiff entered lawfully and did not commit any crime. It could be said arguendo that defendants had reasonable suspicion to investigate and determine if plaintiff and the 14 other individuals would leave peaceably, since they were still in the lobby after 5 p.m. But that does not easily translate into probable cause to arrest the plaintiff. Yeah, it does. You were in there. You were told to leave. You refused to leave. They arrested you. I don't. This isn't rocket science, dude. As a general rule, a person has a right to enter and be upon the public areas of public property. So we have to ask, may a county official revoke such a privilege when the official finds a person to be a nuisance? We think not. Oh, okay. So I'm sure that State versus Shelton, Ohio, this is, okay. She went around to the jailer's door, and we sent her back around to the front door. She came in. At that time, I told her we did not want her back into the sheriff's office. We don't want her making any phone calls to the sheriff's office. So at 10 p.m., she returned to the lobby of the sheriff's office, which I'm assuming was open, and he'd warned her to stay away from the jail. He took her in and arrested her because he told her to stay away from the jail. But it was open to the public. But see, the difference is, Chili, the lobby of that building that you were in was no longer open to the public. Considering the fact that no other individuals were arrested, defendants may not now argue that plaintiff was not arrested for his First Amendment activities, as he was selectively and specifically targeted and called by name. So I believe it is Neves v. Bartlett that the subjective intent of the officers in making the arrest is immaterial as long as objectively they have probable cause to make the arrest. They could do it to be an asshole, they could do it to be mean, but if they had probable cause to make the arrest, it doesn't fucking matter. The court is not going to look at the subjective intent of the officers. They're going to look to see if there was probable cause. If there was probable cause, then the arrest is good. If they had probable cause to arrest you and 14 other people, but they only arrested you, just because they didn't arrest the 14 other people does not change the fact they had probable cause to arrest you. The conscious exercise of some selectivity enforcement is not in itself a violation of the United States Constitution. Yeah. In order for selective enforcement to reach the level of unconstitutional discrimination, the discrimination must be intentional or purposeful. It has to be discrimination. So like if they're only arresting black people, then yeah. That's different. That's discrimination on the basis of race, creed, color, yada, yada, yada. The Ohio Supreme Court has held that in order to demonstrate intentional and purposeful discrimination, the defendant must make a prima facie case showing that while others similarly situated have not generally been proceeded against because of the conduct of the type forming the basis of the charge, the claimant is singled out for prosecution, and the government's discriminatory selection of the claimant for prosecution has been invidious or in bad faith based upon such impermissible consideration as, there it is, race, religion, desire to prevent the claimant from exercising. Oh, this is interesting. Or the desire to prevent the claimant from exercising his or her constitutional rights. Interesting. I don't think this is going to overrule the United States Supreme Court case in Bartlett v. Neves, but we'll see. Hustler magazines. This is the right one, a 1980 case. So apparently, Hustler magazine was being targeted, and other pornographic magazines were not. And Hustler magazine was exercising a constitutional right, First Amendment right. Isn't that weird? And yet, this court said that they did not show an unconstitutional discriminatory prosecution. The defendants need to present testimony from those individuals responsible for deciding the intended course of future prosecutions. Interesting. But these are still excellent citations. Whoever he replaced Dr. Law with is just on point with the citations. I'm really digging it. Like, at first I thought that maybe they were copying from someone, but this is pretty good stuff. These are good citations. I mean, credit where credit is due. He's given good citations. Regarding plaintiff's due process, and he's not citing from Lexis unpublished district court decisions. Regarding plaintiff's due process claims, plaintiff's phone was not returned to plaintiff when he was released from custody. He was required to file a replevin to retrieve the phone. Then it was damaged when it was returned. Additionally, the phone had been searched despite an application for a search warrant being denied. I don't know how he's proved it's been searched, but that's fine. Further, defendants proffer the entry order regarding the replevin action from the state court as evidence that the state court already addressed any damage concerns. However, there was no replevin hearing. The order referred to in Exhibit E was issued after a pretrial criminal hearing had been conducted. Directly after the hearing, Wagner approached plaintiff and handed him his iPhone in a bag. Exhibit E entry demonstrates that the phone was returned to Decastro during the hearing, but it was after the hearing that the phone was returned to plaintiff. Therefore, plaintiff was unable to even view the phone during the hearing, let alone report any damages. Well, replevin is just for the return of the property, dude. It's just for the return of the property. And I believe, if I'm not correct, that you hadn't pled any damages. So, yeah, there you go. This entry did not reflect the actual facts at the time of the hearing and appears to contain a boilerplate sentence regarding damages which did not reflect any actual facts surrounding the hearing. Further, regarding the First Amendment retaliation, defendants state there is no underlying constitutional violation that this claim can rest upon. However, an unlawful arrest based on First Amendment activities is certainly such a violation. People in the building with plaintiff whom were similarly situated were not arrested, but rather Wagner stepped around at least one of those individuals in order to seize plaintiff, as she knew him by name. Well, there's a video. The qualified immunity analysis begins by viewing the allegations in the complaint in the light most favorable to the plaintiff. Once there appears to be a violation of rights secured by the Constitution has been pled, then the analysis moves to whether the rights were clearly established in the specific judicial circuit, i.e., if we're talking about qualified immunity, is it clearly established that police officers cannot arrest someone who's in a building after hours after having been warned multiple times to get out and stating multiple times that he would not get out? Has it been clearly established that it is a violation of that person's First Amendment rights to arrest them for trespass? I don't think it has been. Plaintiff has alleged sufficient facts comprising unlawful arrests that, when construed to be true, constitute the Fourth Amendment violations. He still has a problem that the underlying arrest hasn't been dealt with. He jumped bond. He was released on OR, and he fled. So I don't believe that the district court is going to ever make any determinations as to whether the arrest was unlawful until the criminal action's been completed. Plaintiff has also alleged sufficient facts comprising, was that the Younger abstention? Is that the Younger abstention doctrine? Yeah, Younger abstention doctrine. God, it's almost like I'm a first-year family law attorney. Plaintiff has also alleged sufficient facts comprising unlawful search and seizure of his phone, which construed to be true constitute additional Fourth Amendment violations. Plaintiff has alleged sufficient facts comprising 14th Amendment violations stemming from the phone search and seizure. Qualified immunity attaches when an official's conduct does not violate clearly established statutory or constitutional rights, of which a reasonable person would have known. When an officer raises qualified immunity defense, we determine, 1, whether, considering the allegations in the light most favorable to the party injured, a constitutional right has been violated, and 2, whether that right was clearly established. In the Sixth Circuit, he even got the circuit right. That's pretty good. It is clearly established that an arrest not supported by probable cause violates the Fourth Amendment. Yeah. But is it clearly established that arresting someone in a public building after hours who refuses to leave is a violation of their Fourth Amendment? That'd be crazy. Plaintiff's injuries stem from the incident on March 29, 2022, which is the subject of this suit. The arrest was conducted with no probable cause, thereby eviscerating, that's nice, any qualified immunity. I don't think so. I don't think it's quite that cut and dry, Chili. I mean, wouldn't it be great if every criminal out there could just say, oh, they didn't have probable cause, therefore they don't have qualified immunity, therefore I get to sue them. I don't have to deal with the criminal charge. I just get to sue them, say no probable cause, and have the district court deem the arrest unlawful. QED. To find a municipality liable under Section 1983, a plaintiff must establish that policy promulgates a policy or custom that is the moving force of a violation. How long is this? Jesus. Oh, we're getting there. So it's Manel. You have to plead Manel. An official policy usually exists in the form of written policy statements, ordinances, or regulations, but may also arise in the form of a widespread practice that is so common and well settled as to constitute a custom that fairly represents municipal policy. Manel claims are really hard to get, especially on facts like this, where you were arrested with probable cause. The policy must either be unconstitutional or adopted with deliberate indifference to the known or obvious fact that such constitutional violations would result. Failure to train may represent a policy for which a city may be held liable only if it directly causes injury. The fact that an officer could be unsatisfactorily trained is not enough to trigger the municipality's liability. The plaintiff must show that, number 1, the training policy was deficient, 2, the county was deliberately indifferent to this deficiency in adopting the policy, and 3, the deficient training policy directly caused the constitutional violation. So this is just a little aside. Like, I could see a attorney who had a shit position to deal with writing this. This is pretty good. Like it's sometimes you have a shit argument. You just do. And so you just make the best of your shit argument. This is someone who is making a relatively good stab. That they've really polished this turd. They've done a good job at polishing this turd. Credit where credit is due. This is a very well polished turd. I like it. Sometimes you're representing a client that has no real defense, but they don't want to settle or whatever. And so you got to polish that turd. Someone has polished the living daylights out of this turd. It is like mirror smooth glass. It is a glass turd. However, sufficient proof to find a policymaker ultimately liable under 1983 is a different standard than that needed at the pleading stage to overcome motion made pursuant to 12b-6. So a lot of this, he's just citing case law, just like well-established case law. This is boilerplate stuff you could put in any of these motions, right? And it's because he can't argue the facts, so he's arguing the law. If the facts, if you win on the facts, you argue the facts. If you don't win on the facts, then you argue the law. If you don't win on the facts or the law, then you pound the table and shout like hell. He doesn't have the facts, so he's just putting all this boilerplate. You can't really argue with it law. He's not applying it to his facts well, if at all. But he's putting out this boilerplate law. It makes it look good on the surface. But since he can't really apply it to his facts and win, it's not going to help him. In its motion, defendants essentially made 3 points for dismissal in their brief. Number 1, plaintiff has alleged no facts showing a formal policy. 2, plaintiff has not pled any widespread custom of similar instances, even in conclusory form. And 3, plaintiff has conclusory allegations that the city of Ironton had tolerance or acquiesced to any policy. In the instant case, plaintiff has provided a significant amount of detail in the form of exhibits, which are part of the general factual allegations that support his complaint. So he's clearly shown it. Ginger ale and bourbon. Plaintiff alleges that he was arrested without probable cause, as Wagner and the officer defendants knew plaintiff was not engaged in the act of committing a crime. Further, plaintiff has alleged it was due to the practices of the city of Ironton. As such, plaintiff is only required to plead facts. See, that's an allegation. And then he just said he's only required to plead facts. So what does that even mean? Thus, to survive a motion to dismiss, Grodin needed only to plead facts. Facts that established the change policy was promulgated or ratified by the city's policymaker. But see, he went from allegations to facts. They're different. Court should not grant motions to dismiss on 1983 cases for imperfect statements of the legal theory. We see the court should not grant motions to dismiss for failing to plead the specific identity of the policymaker. You don't have to be too specific, but you have to have some facts, not just allegations. You can't just say, "Oh, Ironton trains its police to arrest people who are using their First Amendment." That's an allegation. You have to plead some facts. On this date, at this time, they arrested this person for the non-crime of just stating their First Amendment position. 39. If the underlying facts were lacking, which is all that is required of plaintiff at the pleading stage, he should be given leave to add them. So he should be allowed to amend his complaint if they're lacking. Conclusion of prayer, wherefore plaintiff has clearly demonstrated that the cause of action are supported with the facts and the exhibits attached to plaintiff's First Amendment complaint. Plaintiff respectfully requests that the defendant's motion be denied in its entirety as discussed in this response, and so that this case can proceed and be decided on the merits. Further, plaintiff has clearly demonstrated that had he not been engaged in the First Amendment protected activities, he would not have been approached or seized by the defendants. So if he hadn't been talking, he could have just stayed in the closed portion of that building all night long, right? So anyway, here is the response. Please God, let it be short. All right, it's fairly short. So this is Wagner et al.'s opposition to his motion for an extension of time to be allowed to file his opposition to their motions. All right. On June 21, 2022, defendants Pam Wagner, yada yada, filed a motion for judgment on the pleadings. Said motion, if granted, would be dispositive of all plaintiffs' claims against the Ironton defendants. Plaintiff never responded to the Ironton defendants' motion, and on July 21, 2022, this court ordered plaintiff show cause by August 11, 2022, why the Ironton defendants' motion should not be construed as unopposed and granted. Plaintiff filed his response to this court's order show cause on August 11, 2022. In plaintiff's response, he claimed that he had received nothing from the court or the Ironton defendants in this action prior to July 27, 2022. In response, on August 15, 2022, this court allowed plaintiff 30 additional days to respond to the Ironton defendants' dispositive motion. Consequently, plaintiff filed his amended complaint on September 15, 2022, exactly 30 days after this court granted plaintiff an additional 30 days, even though plaintiff stated he had been preparing his first amended complaint, which he anticipated filing under Rule 15 as soon as he received any response from the defendants. The Ironton defendants timely filed their answer to plaintiff's amended complaint and an accompanying motion for judgment on the pleading. Again, this court was forced to issue an order show cause on November 7, 2022. Plaintiff failed to respond, and the case was properly dismissed on December 6, 2022. As this court has repeatedly held, while some latitude may be extended to pro se litigants when dealing with sophisticated legal issues, there is no cause for extending this margin to straightforward procedural requirements that a layperson can comprehend easily as a lawyer. As such, pro se litigants must still comply with the procedural rules that govern civil cases. In other words, pro se litigants should not be accorded special consideration when they fail to adhere to readily comprehended court deadlines. Here, it has been over 2 months since Ironton defendants filed their motion for judgment on the pleadings, and plaintiff has still, to this date, not responded to said motions. The Southern District of Ohio Civil Rules 7.2a2 specifically provides that a memorandum in opposition shall be filed within 21 days after the date of service of the motion. Given that this is a procedural rule that sets forth a readily comprehended court deadline, plaintiff should not be accorded special consideration here. In plaintiff's response, he claimed that other than this court's original order to show cause, he has received nothing from the defendants or this court. Plaintiff further indicates in plaintiff's response that his address is 1258 Franklin Street, Santa Monica, California, 90404. However, every single filing by the Ironton defendants in this case, including the notices of appearance, answer to plaintiff's complaint, motion for judgment on the pleadings, answer to plaintiff's amended complaint, motion for judgment on the pleadings, and notice of substitution of counsel contain a certificate of service indicating that they were mailed to plaintiff's above noted address. Additionally, included as Exhibit B to the instant filing are the service letters for each of those filings, which were sent to plaintiff's above noted address. Finally, included as Exhibit C is an affidavit of Raven Clark, attesting to the fact that all of the Ironton defendants' filings in this case were sent to plaintiff's above noted address. Of further importance, it is that since the original motion for judgment on the pleadings and plaintiff's response, the status quo has remained the same. Neither plaintiff's address has changed, nor has he filed a motion to amend his service address. Plaintiff alleges that he has acted in good faith and that he has been hindered as he has not received a number of documents. This simply is not the case. The address listed in the court's docket system, i.e., the address where the court would serve any and all communications, is the same address the defendant Irontons have sent all communications and correspondence to, and is the same address plaintiff utilizes in his own filings. Furthermore, he has now managed to fully respond to our second motion for judgment on the pleadings when he was unable to respond to our prior motion for judgment on the pleadings after being served at the same address. Quite frankly, even if plaintiff did not receive this court's order to show cause, filed on November 7th, 2022, this does not excuse his conduct. Plaintiff was properly served with a motion for judgment on the pleadings via email, and United States Postal Service. Plaintiff was already on notice from his prior filings and interactions with this court of the need to respond to the motion for judgment on the pleadings, and failing to do so would result in an order to show cause. Nevertheless, he failed to timely respond to both. Furthermore, he made no additional efforts to contact the Ironton defendants or the court for an extension. This conduct should not be rewarded. Plaintiff's piecemeal adoption of when service has and has not been perfected has inexplicably and seemingly worked in his favor at every turn, and once every responsive deadline has come and gone. Plaintiff is clearly acting in bad faith. Thus, service is not the issue in this matter. Rather, it is plaintiff's dilatory conduct, and this conduct alone, that is the crux of this matter. Plaintiff's motion for leave to file a response is clearly a last-ditch effort to excuse his own lack of attention to this matter, as demonstrated by Exhibits A, B, C, and D attached hereon. Thus, the court should deny his motion and affirm its December 6, 2022 dismissal of the action. And then yada yada. So how is it going to break out? Well, number one, we haven't seen a response yet from Chapman, Jane Doe, and Lawrence County. So we're missing a response still. With that said, that's a tough call. The case is closed, and the courts can be it's not going to want to reopen it. On the other hand, Chile missed his deadline, his final deadline, by 2 days. He didn't put in a declaration from his process server, so that's bad. It's a tough call. I can see the court being like, okay, we'll let this dipshit have another shot. But the court could say, we'll let this dipshit have another shot, and then we will find for the defendants on the motion for judgment on the pleadings. So there's a couple ways the court could get rid of it, but I think the court's going to get rid of it. If I was going to bet on it, the court's going to get rid of it, either by denying Chile's motion, which, I mean, there's a good chance of it, but I kind of think the court would rather grant his motion and then rule on the motion for judgment on the pleading and get rid of it that way. But I don't know. I really don't know. It's a tough call. I'm leaning towards the court. Oh, it's a tough call. I think the court's going to get rid of it either way. If I was going to bet, I'd bet the court gets rid of it. Anyway, I'm probably wrong on that. I always think the court's going to get rid of it, like, especially when someone does something like Chile's done. I've seen it in the past so many times where, in cases I've been in, where opposing party or opposing counsel has just completely blown off all of their time constraints, and then they come in like way late, and judgment gets set aside or whatever. It's really annoying. judges are very, very prone to setting aside judgments that are gained basically by one party just effing off. But in this case, I'm going to be cautiously hopeful that the court will kick it out. Between the two of them, I think the court's going to kick it out. It's a tough call. I don't know. That's a tough call. Anyway, flip a coin on that. Thanks for watching. Have a great day.